He's already on level 3 and he's blatantly committing new crime. Not just new crime, but serious, significant crime. A controlled delivery was conducted at that address on June 9th of this year. And then a subsequent residential search warrant located the package at that address in possession of Mr. Lowe. And he subsequently gave a tape statement to law enforcement indicating he did in fact order and receive the package containing the tapentadol, as well as there was other items found during the search warrant. I believe it was liquid morphine and some paraphernalia that helped support the ultimate charges in this case. So based on that investigation and the search warrant, Mr. Lowe was charged with first degree, maintaining a manufacturing facility, as well as multiple other CDS accounts, 2 for manufacturing, distributing, both second degrees, and then a third degree possession of CDS. He has a host of pending charges prior to this matter from a year ago. Those charges range from first degree racketeering, first degree money laundering. There's a second degree promoting organized street crime in there, which is important to note because it's a consecutive mandatory to that racketeering charge. So he's currently on level 3 release for those charges, based on accruing new charges while on level 3 release. The state is moving to detain Mr. Lowe on these set of charges.
All right, let's move on to detention. Ms. Parvin.
Judge, the defendant scores a 4 for failing to appear and a 3 for new criminal activity. He has arrests out of state. He had some federal charges as well previously. He's got a previous probation violation. He's got significant pending charges prior to this, as I've already stated, with exposures of, I don't think I added them all up in my head, but I would imagine somewhere in the 30s for exposure, if not higher, in conjunction with this case. I mean, he's at this point, based on his age, he's looking at a life sentence that he's exposed to for all of these charges. His flight risk is significant based on the prior history and the seriousness of these charges. We are asking that he be detained until these charges are resolved.
Bell.
Thank you, Judge. The PSA recommends level 1 release.
Level 3.
I understand the PSA recommends level 1. So to go from level 1 recommendation, I will concur with Ms. Parvin in that there were federal convictions that I don't think were evaluated in the PSA. The state provided me with the documentation with regard to those. That notwithstanding, I don't know that those having been factored appropriately would go from a level 1 to a no release recommendation. This is not a violent crime. This was not a long-term investigation as we had been seeing in the cases that came prior today. This is, Mr. Lowe was not a target of law enforcement investigation. This was an unfortunate event that landed him here. Mr. Lowe he has a record. However, he doesn't have any prior failure to appear in the last 2 years. He has a few from, I forget when, but it was a couple years ago, and they were right about the same time as each other. So, Judge, I would ask you to consider that. He has, upon his arrest here, he immediately gave a statement to the police, thereby acknowledging and I think giving weight to the argument that he's not trying to obstruct the process or do anything to flee. He has taken responsibility. He gave a statement. He's got a job. He's got a good job. He owns a construction company or something of the like. He has employees. He has people that work for him. He I will ask him to give me more information about that, but that I think is important to Your Honor to note. Yeah, if he's convicted here, he's looking at a very heavy heavy sentence. But for now, the state has not filed a motion to revoke his release on the first charges. I understand that these are first degree charges that he was already had been released on heavy charges, as it were. But we need to look at this case for itself. And yes, it's a first degree drug case, but it's a first degree drug case. There's no weapons involved. There's no obstruction. There's no attempt to obstruct. And there's only, from what I can tell, been compliance and a desire to cooperate with the process of this prosecution and let it be what it may. Judge, I understand, Mr. Lowe has a residence, he has a business, he has employees, he has a family. I think that the PSA recommendation is appropriate at level 1, but I will ask Your Honor to give him level 3.
Judge, can I respond?
Yeah.
I agree that they're not violent charges, but they're absolutely dangerous. This type of narcotic is a very high potency, very addictive, and that in and of itself, creates the problem of the opioid crisis in America. Like this is the type of drugs that we are creating dangerous situations in our country. So I would agree they're not violent, but they're extremely dangerous. He's already on level 3 and he's blatantly committing new crime. Not just new crime, but serious, significant crime. I just want to say, I get that. I don't know why he scores level 1. I give no, it's a computer that spits out a number based on, calculations. It doesn't have common sense. You see people with DP shopliftings that are recommended to be detained, and you have somebody with first degree life exposure that's getting a level 1. It doesn't make any sense. So what makes sense here is he's level 3. He's violating already. He needs to be detained.
If you would, for me, please, give me an idea of the federal charges here that were not included.
Judge, I can cite them from. Did you get any of the exhibits? There's a report that actually outlines the federal charges in them.
No,
I'm going to pull them up. I have it in front of me.
Judge, they were distribution type offenses.
They were drugs. That's correct. There were 5.
I served 13 years
That's accurate. Yep.
and I completed everything successfully.
okay, that's good to know, sir. Thank you. I do not understand why the PSA would have eliminated that and why they didn't consider it. I think that is a serious problem with the PSA recommendation. The PSA recommendation is not reflective of the actual individual and the risk that individual presents. As such, the PSA recommendation, I think, is not viable in this particular case. It's incomplete. The other thing I look at here is that the PSA does give me other information that is very relevant, and that is the other pending charges for which he's already on level 3 release. What we have here is we have pieces of a puzzle, and I can see them. We have the pending charges now, which are maintaining a CDS production facility, and the other pending charges, which are money laundering, first degree, 2 counts, and racketeering, second degree. And then there are all these dogfighting charges after that, are all 3rd degree, and then leader of a dogfighting network, 2nd degree. So what we have here is we have what appears to the court the allegations of an entire industry here. Production of drugs, laundering of money, corporation of dogfighting, which is a illegal gambling facility. It is an extensive picture that the PSA is not capturing. Now, he's presumed innocent of all these charges, which is what Ms. Bell was about to point out to me. What did you have there, Ms. Bell?
I don't want you to rule before I've had an opportunity. If Your Honor, I understand Your Honor's concern with regard to the accuracy of the PSA, of the
Yeah.
PSR.
Mhm.
However, if Your Honor is going to disregard it in order to interpret outside of that, I would ask that Your Honor order that a new PSR be run before you make a decision so that we can see if
No,
it can be
one
run with those
second.
charges.
Yeah, sorry, I don't do that.
And Judge, just for the record, the federal charges that I mentioned earlier, what's documented in the report is 5 federal arrests, 3 arrests in the state of Maryland. And the criminal history included CDS, theft, manufacturing, counterfeit currency, and probation violation.
On that one, he was a 3-2
What was the recommendation?
with a recommendation release with monthly reporting.
So that was a level 1 recommendation then. Okay. Well, they're relatively consistent across the board. Yes, Mr. Lowe, you want to say something?
No,
I would just like,
What is it?
no, it's about my medical. I spent all morning in medical. They took a lot of blood from me because yesterday during my physical, they found a very large growth on my left testicle. So they're taking, thank God I came to jail because I would have never found it. But it's attached to me, and they said it's larger than my thumb. And I just want to make sure I get the proper care no matter where I'm at.
Well, they'll be required to provide that to you, sir. If you need medical attention, and it will be provided to you. All right, I'm taking a look. Yes, Ms. Farben.
Just to note, Judge, that PSA is absolutely wrong because it does not include prior sentences of incarceration over 14 days for those federal convictions that the defendant already put on the record that he served a 14-year sentence on. So I just wanted to make note of that.
The PSA here indicates no record of incarceration. That is a significant, absence from apparently both of the PSAs that were run in his particular case. So I find that the PSA is not really informative to the court with regard to the issue of detention. What I do find is that he's out on level 3 and is incurring significant charges that are consistent with the allegations that he was already been released on and apparently had been previously convicted on under the federal charge, because those are similar criminal organizational convictions coming predominantly in the federal system out of Maryland. So what I have here is I have a picture of what kind of a risk is this gentleman presenting upon release, and how likely is he to comply with pretrial conditions. And I find that he's not likely to comply at all. He's not going to change what he's doing. He went to federal prison, spent 13 years there, and he comes back out and he's apparently right back at it. And here we go. One thing after another, pretrial release. It doesn't deter him. He continues to incur new offenses. And we have a substantial, what appears to be criminal enterprise here in some of the most dangerous aspects of organized crime, which is the distribution of very serious opioids and the manufacturing of them. So in the end, I'm not saying he did it, but I'm saying what kind of a risk is it? It's a tremendous risk. And it's a tremendous risk. The local population gets out into circulation, and it is as addictive and as powerful as indicated by the prosecutor here, the attorney general here. It's a serious problem. And he admitted that he obtained and ordered the information, so the strength of the state's case very high. So what we have here is a recommendation from the PSA that is below what he's currently reporting on, which didn't deter him, which is clearly inaccurate. And I am not guided by it. So regardless of whether the state, and I don't know why the state didn't move to revoke, but that's not my job to figure that out. But in the end, this matter here is clear to me that a level 1 release is insufficient. Quite frankly, a level 3 is insufficient because it was already on level 3. I don't find that there are any conditions at this point that would be placed upon this individual that's going to control him. He's going to do what he wants to do, regardless. So in the end, there is no other alternative here. I am going to detain him. I am satisfied that the state has established by clear and convincing evidence that there are no conditions of release that are going to adequately address his risk. I also find that he is a flight risk. He has out-of-state connections. He is facing now a potential life sentence, particularly given his prior criminal conviction record, which wasn't even incorporated into the PSA here. So with that, I am going to order he be detained. Now, Mr. Lowe, you do have a right to appeal this decision. That appeal has to be filed electronically within 7 days. You must likewise obtain a transcript of today's proceeding that can be should be ordered electronically and expedited so that it can be produced in that same 7-day period for the appellate to review if that's what you choose to do. You can, Ms. Bell has the ability to make that application for you if that's what you want. Otherwise,
Yes, sir. I would like to.
Well, that's between you and Ms. Bell. It's a decision
Okay.
her and make that decision. Now, your next court date, you're going to be in front of Judge Arbitier. That's going to be on August 7th at 9 o'clock in the morning. That will be in her courtroom, 339 in the Cumberland County Courthouse, 2 doors down from mine. And that's going to be a rather important date. Your attorney will have probably even more information concerning these charges, and you can make some decisions at that point. All right. Thank you very much.
Will that be in person or be video also?
No, you'll be in part. No, you'll be in the courtroom. You'll be in the courtroom. Good luck, Mr. Lowe. Thank you.
Yeah, thank you.
One of y'all can shoot. You out, sir? Yeah.
Is that my business?
I'm not out. No? All right. All right, well.